Backstage. Okay. Come on. Okay, backstage.
All right, I think we're ready to get started. For startup founders. We have a fantastic group of speakers today. We'll get right to the program, but before we begin, just a few quick thank you and announcements. Again, let me see, advance, perfect. A little bit about New York Tech Alliance. We are a nonprofit organization here in New York City driving access, equity, and inclusion in the New York tech community to make it the most diverse and dynamic in the world. Be sure to check us out at nytech.org. And again, if you'd like to connect, my email is right there, andy@nytech.org. A quick statement about privacy. We do record this session, so if you are asked to come on camera or say something, unmute yourself. Just be aware that we are recording. If not, please use the chat function or the questions function on the sidebar to ask those questions, and we'll be sure to get to them at the end of the event. Thank you so much to all of our annual partners that make the work that we do possible at the Alliance. Everybody from Crown Castle to Work Better, great service providers within the tech community. Today we have Paul Ellis Law Group with us, as well as Savity & Associates. So be sure to check out all of their pages on our website, nytech.org. Or if you'd like to connect with any of our partners, please feel free to reach out. There's 3 ways that you can support the New York Tech Alliance. One is by making a small donation when you RSVP for virtual events, become an individual or supporting or corporate partner of New York Tech Alliance, or simply make a small donation. You can find all of that information again at our events. We appreciate all the support we've received this year, and it's allowed us to continue the work that we're doing. Be sure to mark your calendars for our next event happening Tuesday, March 9th at 5:30 p.m. It's our March 2021 New York Tech Meetup. We are putting together a fantastic roster of amazing technologists showcasing great technology from startups. And we hope that you can join us for that event. Always keep up to date with our events at nytech.org/our-events. And with that, I'm going to turn over the session to Paul Ellis, who will be moderating the panel and turning it over to the other 2 speakers. So Paul, please take it away.
All right, very good. Andy, thank you very much. Good afternoon, everyone. Welcome to our event, Your Ownership and Rights, IP for Startup Founders. Again, my name is Paul Ellis. I am the principal of the Paul Ellis Law Group. I'm a board member here at New York Tech Alliance, and I organize a lot of the events for the organization on legal issues for startup founders and principals. So we have a great event today, a really important topic. I'm going to start by just doing a quick round, introduce everyone, and then we will get into our substance. So again, my name is Paul Ellis, principal of the Paul Ellis Law Group. We are a 10-person boutique firm in Midtown New York. We do a lot of work with small to mid-size startup tech and tech-enabled companies, as well as investors, co-founders, and key employees of those companies. Our clients are looking for us to identify cost-effective, efficient solutions for their legal needs so they can focus on building and growing their businesses. In addition to addressing issues like the ones we're talking about today, IP protection, we also work on formation of companies, on negotiating and closing rounds of financing, on equity plans, employment agreements, general operational matters, and buying and selling companies when it comes time for an exit. Everyone in the firm comes out of top law schools and big New York law firms, so we're able to offer the expertise of a big firm with the more personalized attention and cost-effective billing structure of a boutique firm. Joining me on the panel today, we have Ted Savity. Ted is the principal attorney at Savity & Associates, an intellectual property firm that understands innovative technology and electronic media businesses and the creative people that drive their success. His law practice focuses on businesses whose primary assets are advanced technology, software, creative works, and digital media, whether patents, trademarks, or copyrights, IT infrastructure, or electronic content distribution. Ted and his colleagues have done deals, conducted litigation, and procured IP registration for clients around the world. Issues for many of my clients, and really outstanding in the work that he does. So really pleased to have him with us today. Also on the panel is my colleague, Jessica Friedman, counsel to my firm, Paul Ellis Law Group. Jessica has practiced copyright, trademark, media, and licensing law in New York City for over 30 years. Among the matters Jessica handles are content, data, and technology development and licensing agreements, publishing agreements for authors and publishers, collaboration agreements, literary agency agreements, media agency agreements, MSAs and other commercial contracts, as well as online and mobile app privacy policies and terms of use. She also conducts fair use and work for hire analysis, domestic and international trademark clearance, prosecution, licensing, and policing, and she handles other matters related to rights of privacy and publicity. In an earlier life as a litigation associate, she represented clients in copyright and trademark infringement litigation, and for 14 years, she served as part-time general counsel to a healthcare communications company. So really pleased to have Jessica as well. Jessica and I have also been working together for many, many years, and she's really an invaluable part of my firm in terms of our IP protection practice. So with that, we can jump in a little bit into our substance. I'm just going to say a few words in terms of background, and then I'm going to turn it over to the team. I think we have a group here of attendees. Many of you are startup founders and principals, and for that reason, you recognize that IP is really critically important to your business. I'm a corporate lawyer, but I find that when I sit down with new clients, IP is often the first issue that comes up. They want to talk about a trademark. They want to talk about a copyright. They want to talk about their code, how to protect it, or to make sure that they have their rights due to the fact they've coming from a previous employer that had where they had certain contractual restrictions. So these are often the first issues that you all have to deal with as startup founders. I think you also recognize that the IP is critical to the value of your business and critical to the growth of your business, and it will come up again and again through the life cycle. Investors are going to want to do a deep dive on in the diligence process on your IP to make sure that you have ownership rights, you've got good chain of title. Strategic partners, joint venture partners, and especially when it comes time to sell the company. I do a lot of exit work, buying, selling my clients' companies when it's time for an exit. And I can tell you, nothing can derail a deal faster than IP issues, because the buyer is always going to want to do a deep dive and look at the chain of title, make sure that the company they're buying has good rights to the IP on which it's built. And in the process, sometimes things will come up. Especially I'll often get called in to sell a company that I didn't represent it along the way. And when we're preparing the company for diligence, things will come up, and hopefully we identify it before the buyer finds out. But that can slow down the process. Generally, it doesn't derail a deal, but it can affect the purchase price. It can slow things down. It can affect deal terms. So these are really critical issues that you need to focus on. It's a big topic. We're not going to be able to give you all the answers, but we hope to at least identify the questions. We like to think of it as issue spotting, to help you to understand. So when something comes along in growing your company or whatever it is, you'll remember, those IP lawyers, they mentioned that. And you'll know that's an issue you need to focus on, and you need to reach out to IP counsel to help you with it. A couple of other things I should note. We're going to be focusing primarily on US law, although both Jessica and Ted are certainly familiar working with affiliate counsel around the world on helping people with international IP rights. Also, with respect to Q&A, we have a chat function. You can enter your questions. We also collected a bunch of questions in the registration process. At the end, we will get to as many questions as we can, but we have at least 75 or 80 attendees, so a lot of questions. We'll do the best we can. I believe that Jessica and Ted will both be able to stay afterwards in the networking area at their virtual tables. So if we don't get to your question during the event, there'll be an opportunity afterwards. I should also mention this video will be distributed to everyone who registered for today's event. So with that, I'll stop talking. I'm going to turn it over to Jessica for the first segment, and then we'll go to Ted. Jessica, take it away.
Okay. Can you see my slides? Yes?
We can see the first slide with
Great, that's all I need. I just wanted to make sure. Okay, so I am going to jump right in. I don't have a lot of time, but so I'm going to start with trademark, and I just thought I'd ask, what is a trademark? Or if you're talking about services, what's a service mark? A trademark is a word, a slogan, or a combination that identifies the source of products or services. It's your brand. And when consumers recognize that brand and they look for your product or service because they think it's good, we say that that trademark has acquired goodwill. Goodwill is what makes a trademark valuable. So when you are choosing a name for your new company or your new product or division or service, it's really crucial that you choose a name that can legally function as a trademark, because not every word or slogan can. There's a spectrum of marks. If you are making chairs and you want the brand name to be chair, well, you can't do that. That's generic. You can't give it the name of the thing itself. If you use a merely descriptive mark, a mark that describes the product, an ingredient of the product, the audience, or something like that, you won't be able to protect that name, claim it as yours, and stop others from using it until it has acquired distinctiveness, until people come to recognize that it's yours. For example, think of the name TV Guide, completely descriptive, but when you hear it, you think of one particular publication. That's a mark that has acquired distinctiveness. Your best marks are, for example, a suggestive mark. Think of the magazine Smart Money. There's no such thing as smart money, but the idea is that magazine will help you become smart about your money. An even stronger mark is an arbitrary mark. That's a regular word applied to something new, like BlackBerry for a PDA or Arrow for shirts. And the strongest kind of mark is a fanciful mark, preferably a mark that's completely made up. Think of Kodak, even though they're not around anymore. That was a very strong mark, and it was a made-up mark. So if it can't legally function as a mark, a trademark, you can't stop other people from using it. Now, the other question you have to think about when you're choosing your brand name is clearing the rights. Is your mark going to infringe anyone else's mark? You need to make sure that it won't before you start to use it, because otherwise, as soon as your business gets going, you may find yourself hit with a cease and desist letter, or worse, served with an infringement complaint. So what does it mean to infringe somebody else's mark? Your mark will infringe someone else's mark if it is likely that consumers will be confused into thinking that your product is really coming from the other guy, that the other guy endorses your product because the marks are so similar, or that there's just some affiliation between the two. So how do you determine whether your mark is likely to be confused with someone else's mark, that there's a likelihood of confusion? There are several factors that a court would look at, and you should too. First is, how close are the marks to each other, visually, orally, and in meaning? Are they confusingly similar? The marks don't have to be identical to be confusingly similar. They can even be reversed components like backhand and handback. The key is whether a court will think that they make the same commercial impression. The next question would be, how close are your goods or services to the goods and services that someone else is already providing under a similar mark? Again, they don't have to be identical. Many goods and services are considered to be related because many companies offer both of those services or sell both those goods. There are other factors. There's the channels of marketing and distribution. Are you retail or wholesale? What is your intent in choosing this mark? Are you really trying to confuse somebody else's customers? What is the possibility, even if you find a mark that's close and the other guy is not doing, or girl, is not doing exactly that thing, what are the chances that they're going to bridge the gap? The key thing to remember here is that the junior user, that's you, the second person coming along, has a legal duty to choose a mark that won't infringe somebody else's mark. So how do you determine whether, to make this analysis, how do you determine whether your mark is going to infringe somebody's mark? Just a few points here. Getting the domain name is not enough. Incorporating under the name is not enough. A Google search is not enough, although it's helpful before you start to use a name to do that, to make sure that there's no other products out there with your name. Even searching the database of the U.S. Patent and Trademark Office, so we call it the PTO, is a good start, but it's not enough, and it's really not great if you do it yourself, because unless you really know what you're looking for, you know how to interpret the data there and how to follow that up. And searching the PTO database is also not enough, because that only shows marks that are registered or applied for in the PTO. In the United States, the first person to use a mark has the superior rights, not the first person to register. So you go through registration, you haven't done a full search, and bingo, you find you're being served with a complaint for infringement by somebody who never applied to register their mark in the PTO, but they used it first, and the mark is confusingly similar and the goods are related. To avoid that, you really need to have a trademark lawyer do something called a full search or a comprehensive search. And I would say, I cannot say strongly enough, avoid cheap trademark services that say that they're clearing your rights for like $300. They are not. They are not even doing enough of a search in the trademark office, and they're certainly not doing a full search. Of course, how much you want to search will be determined by your budget and your tolerance for risk. You can say, okay, I'm just going to do this. I'm not going to do the full search. That's up to you. So let's say that you have searched a mark, you found a mark that you think is a legitimate mark and you're not infringing anybody else. How do you protect it? So the first thing is you apply to register it in the PTO if eligible. Now you may say, well, you just told me that even if I register it, somebody can sue me for infringement. Why should I bother? There are some key advantages to a federal trademark registration. One is that if you are involved in an infringement situation, if somebody is charging you with infringement or you want to sue somebody else, it shifts the burden of proof to the other side. Everything that's stated in that registration, the date of first use, the owner and all that, is presumed to be true. And that therefore your lawyers don't have to spend time proving it. And you know that if lawyers have to spend time doing anything, that involves fees. The other thing is, as soon as you file a federal trademark application, it shows up in the PTO database, so people who are searching will see it. Registration is constructive notice of your rights. So if you claim that somebody is infringing your registered mark and they say, oh, I didn't know that was your mark. Once you have a registration, they are deemed to know. And it's also a prima facie defense to infringement. Now, notice the slide says there, if you are eligible, you cannot get a federal registration unless you are using your mark in interstate or international commerce. So if you're making goods, and there's so many details to this, but if you're shipping goods, you've got to ship them out of state to be using it in interstate commerce. If you're providing services, you have to be providing them to people who come from other states. Now, you can apply to register your mark before you have used it on an intent to use basis if you had a bona fide, good faith intent to use the mark in interstate or international commerce, in commerce. So how do you apply? You can do it through the PTO website, but just because anybody can do it, again, doesn't mean you should do it. You really need to know what they're doing, and there's a lot of tricks and traps there. You've got to identify the correct owner of the mark from the get-go, or the application's invalid. You've got to make sure you're filing in the right international class. Every trademark, every good or service is in one of 45 international classes. You have to make sure you're stating the correct date of first use. That can be tricky. Identifying the correct goods and services can be tricky. You don't really want to file an application that lists every single listing in the PTO database, because that can cause you problems down the line. submitting a specimen of use. Okay, you will not be able to register your mark until you actually have used it, and you have to submit a specimen of use. That's really tricky, especially now the PTO is cracking down really hard on specimens because so many foreign applicants submit doctored specimens. Again, don't use cheap registration services to do this. I know that sounds self-serving, but they will not ask you the right questions, and 9 times out of 10, your registration will end up flawed, and when you try to enforce it, you will have a problem. Also protect your mark by using it continuously. If you register your mark, you're going to have to file an affidavit 5 or 6 years down the line that says you're still using it. And you also don't want to be in a position where it could be said that you abandoned your mark by not using it. That is a very high bar with very specific requirements, but you don't want to go there. Use your mark consistently. If your mark is a word with a red star, don't change it to a green star. If your mark is, as I said, backhand, don't change it to backhanding, because you may not be able to maintain your registration and your rights if you're not using the mark that you started out with. Police your mark. We can explain more about what this means, but in other words, keep an eye out to make sure no one else is using your mark in a way that would infringe. Again, if you don't police your mark and other people are out there using it, you may be found to have abandoned your rights. Last but not least, do not let anyone else use your mark if someone comes to you without a proper trademark license and quality control. A license is an agreement by which X, the licensor, lets Y, the licensee, use their intellectual property under certain terms and conditions, which usually include paying a royalty. If the licensee breaches the license, the licensor can terminate it. Now, the key term of a trademark license is quality control. Your license has to say that the licensor gets to examine and approve the quality of the goods or services. Without this, your license is what we call a naked license, and it can lead to a finding of abandonment. Again, that's more complicated, but you don't want to go there. Even more important, whatever your license says, you've got to exercise quality control. You've got to make sure that whatever is being sold to the public under your name is of the quality that you want it to be. Even if your license says you're exercising quality control, but somebody says you're not and you've abandoned your rights, if you haven't done it, you may lose your rights. Okay. Remember I mentioned goodwill earlier, the positive consumer association with a mark. A trademark cannot be legally sold without the goodwill. So if somebody purports to sell you a trademark and the agreement doesn't talk about the associated goodwill, you will not have the right to that mark. That can really screw you up. So how do you avoid trademark infringement other than the ways I already discussed in choosing your brand name? The simplest rule is don't use anyone else's trademark without a license, unless your trademark lawyer says it's okay. So don't display other people's marks on your site without permission, because that suggests that those people endorse your service or product. And remember, endorsement, seeming to endorse, is one form of trademark infringement. Now, there are some situations in which it's fine to do that. Like if you're a licensed Audi dealer, of course, your site should say, I am a licensed Audi dealer. If you run a site that reviews the performance of various bands, you should be able to use the names of those bands to describe what they're doing. But you just have to be careful. That is all I have to say about trademark for the moment. Let's see how far behind I am. Yep, I'm far behind. Okay. On to copyright. In the United States, there's no common law copyright. All copyright is covered by the Copyright Act of 1976. Now, what kinds of things are protected by copyright? So copyright protection here subsists in original works of authorship fixed in any tangible medium of expression. So what's a work? A work is any kind of content, a movie, source code, a song. Originality is a very low bar. Basically, it means the work has to have been independently created. You didn't copy it, and it has a minimal level of creativity. Copyright law does not protect ideas, concepts, procedures, processes, systems, or facts. There's some protection for compilations of facts, like a database, but that protection is very thin. It protects the selection, coordination, and arrangement of those facts. So somebody can cherry pick facts from your database, and they're not infringing your copyright. There's also special hurdles for you to jump if you want to claim copyright in a functional work, such as a belt buckle or a lamp or a bicycle rack. And fixation, that was the other requirement, means it's written down, it's coded, something more than speaking it off the top of your head. So the copyright owner has 5 exclusive rights: the right to reproduce the work, which is upload, download; create derivative works, which are adaptations, a translation from English to French, an arrangement of somebody else's song. Those are derivative works. Distribute copies of the work, which includes transmitting them electronically; publicly perform the work, and publicly display the work. If you're the owner of a sound recording, you have a special right to transmit that recording digitally. So infringement in the copyright context means doing any of the things I just said without permission or helping somebody else do them. Now, here's a few basic rules for avoiding copyright infringement. The fact that material is posted online does not mean you can use it without permission, okay? There are copyright troll lawyers, some of them very notorious, that will come after you demanding ridiculously high, thousands of dollars fees for a mistake you made in having posted some thumbnail sketch online. This happened at our offices just last week. It happens all the time. When you do get permission, if you go to someone and ask for permission, make sure you get the rights you need to do what you want. Ted will talk about this, I think, in connection with software licenses. But let's say you want to perform a song, your band wants to play a song in a restaurant, you need a performance license. If you want to release a recording of somebody else's song, you need a mechanical rights license. For text and art, you may have heard of a copyright commons license. A lot of people assume that a work covered by a copyright commons license is free for you to do whatever you want with. That is not true. Even those licenses sometimes have certain requirements. Get a license from the right person. Make sure the person you're getting it from has the right to give it to you. If they don't have the right to give it to you, it's all well and good that they purported to license it, but you could be liable for infringement. Get an indemnity from the licensor. The licensor should put his money where his mouth is and promise that if you are sued for copyright infringement on account of your use of this work that you're licensing, they will either defend you or pay your legal fees. Now, in connection with this, I should just say, there's so many issues out here, but for example, a lot of the free clip art sites have terms of use that specifically say, we don't promise that we actually have the right to let you use this stuff, and if you get sued, that is your problem. Last, know and adhere to the terms of any license you enter into, especially if your license is contingent on your fulfilling those conditions. Make sure the people who work for you do know the terms also, especially summer interns. Summer interns can get companies into a lot of trouble, posting unauthorized works on websites and so on. Be very careful when linking, okay? Linking used to be fine, dandy, anybody could do it, but recent cases have rejected what we call the server test. The test for linking, whether you could link, used to be you could only be liable for infringement if your server actually hosted the other person's copyrighted work. A couple of courts have called that into question. That is no longer necessarily the case. The reasoning is that particular rationale applied only to search engines, and it doesn't apply to posting embedding photos in regular media. By the way, the European Union actually requires service providers to get licenses with the publishers of press publications before engaging in any online linking. The other thing is be careful using works that you think are in the public domain. When was it? January 1st of this year, I think, that works from 1925 went into the public domain, like The Great Gatsby. But be careful, again, if it's posted online, it's not necessarily PD. There's something called restored copyrights in foreign works that went into the public domain, but the copyright was then restored. Be very careful. Be afraid. Be very afraid. Okay, can you ever safely use someone else's copyrighted work without a license? Not exactly. In some circumstances, there may be, the law may excuse copying, which gives you a defense to an infringement claim, but you need to know exactly what the parameters of that defense are. So the first one that is most widely known, but most widely interpreted, is fair use. Fair use is not what you think is fair. If you are sued for copyright infringement and you want to invoke the fair use defense, the court will look at 4 statutory factors that are listed here that I just don't have time to go through, but they will also look at whatever the court considers relevant. If it's very obvious that you tried to scoop, you're a newspaper, you tried to scoop somebody else's story, that's going to weigh against you. Fair use has been the subject of entire day-long seminars, so it's quite complicated, but it's not what you think is fair. There are other legal excuses for copying somebody else's work. One is implied license. Again, it's not what you think is implied. Implied license, use of a work under an implied license is subject to specific legal principles. And if those facts are not there, you don't have an implied license. Another thing is de minimis. We only showed that painting for a split second in the movie. Again, you should check whether your use is really de minimis. The Digital Millennium Copyright Act, you may have heard of the DMCA, offers some safe harbors, some situations in which copying will be excused if you comply with certain requirements. Two general requirements for being eligible for the DMCA. You have to have a policy for terminating people who repeatedly infringe, and you also have to not interfere with somebody else's copyright protection measures. Section 512, what you see, which you might have heard of, limits your liability for user-generated content, what other people post on your site. Again, under certain circumstances, you must have appointed an agent for claims in the Copyright Office. You have to have no actual or constructive knowledge of the infringement being alleged. And if somebody sends you a notice that says you're infringing my copyright, take down my stuff, you must respond promptly, at least if it's a DMCA compliant notice. Okay. If you have a site that allows user-generated content, your terms of use should specifically prohibit people from posting content that they don't own or have a right to post. But by the way, unless you make people agree to your terms of use, or unless your terms of use are where they cannot be missed, like there's a notice across the top that says, by using this site, you agree, those terms of use will not be enforceable. So just putting them at the bottom with a link that nobody's going to see, that's not going to help you. So far, I've talked about making sure you don't infringe somebody else's content. What about when somebody creates content for you? How do you make sure it's yours? Well, you should know the default rule is that in copyright, the creator of a work, who in copyright is called the author, owns it, okay, no matter what. The only exception to this rule, the only exception, is in a situation where the work is work for hire, work made for hire. This is a phrase that is thrown around and misused a lot. A work can be work for hire in only two specific situations. The first is it's a work prepared by an employee in the scope of their employment. It's not always clear when someone is an employee, and it's not always clear when something was created in the scope of their employment. The second kind of work for hire is a specially commissioned work. So you ask somebody outside your company to do it if it falls into one of 9 categories listed in the Copyright Act, okay? And there's an agreement in writing signed by both parties that says this is work for hire. Okay, if many works don't fall into those categories, for example, a book, a series of books, a musical composition, so you need to know. And the thing is, if a work doesn't fit into one of these two paradigms, it is not work for hire, and the creator owns it from the get-go. Now, you may say, somebody's creating content for you, they're not in your company, and the work doesn't fall into the 9 categories. How can you own that? You get an assignment of copyright, like a bill of sale on a house. That way, even if the creator owned the work to start with, you can come to own it. Now, you might say, well, you just told me if I can assign the copyright in the work, why does it matter whether the work is for hire? It matters because a work made for hire is not subject to termination. And by termination, I mean the special copyright termination right. This is a right that the Copyright Act gives creators to, after 35 years, rescind any grant that they may have made because maybe they made a bad deal and maybe they should be able to get more money for it. If we're talking about software, the chances that it's going to be in use in 35 years are pretty slim. So in my opinion, whether software is a work for hire is not that important. Ted may have a different opinion. So there's other reasons why it's important, but the most important reason is that a work for hire is not subject to termination. Any agreement that you sign with someone who's creating work for you should state that the work is work for hire, if applicable. But in case it's not, the creator assigns all their rights to you. It's belt and suspenders. So if you're creating a work with somebody else, you're writing a play together, or a bunch of you are creating an audiovisual project, you need an agreement that says who's going to own copyright, or is it going to be jointly owned, and also provides for other terms that are important. Don't assume that just because you're working with somebody else, the work will be 50-50 copyright ownership. There are certain default rules under copyright about that, and they may not work out in your favor. So now you have a work whose copyright you own one way or another. So how do you protect it? Apply to register it for copyright ASAP, and especially before you distribute copies of the work to the public. Why? Because you cannot get into court to sue for infringement without a registration, not an application, a registration. Also, if someone infringes your copyright and you sue them and you win, if you registered the work before the infringement or within 3 months of offering the work to the public, you're eligible for two major remedies. First of all, if you win, you can get your attorney's fees. The other side has to pay your lawyer's fees, or some of them anyway. And the other advantage is if you win, you can get something called statutory damages. Statutory damages are damages that a court is entitled to award within set ranges, even if you can't prove that you lost any money. Okay, that's a very nice remedy to have, but you cannot get that unless you register the work before the infringement or within 3 months of offering it to the public. Another way to protect your copyrights is to use non-disclosure agreements when you submit your works or proposals to others, and make sure that any agreement you enter into with someone includes appropriate confidentiality provisions. Now, this isn't always going to work. If you want to submit your proposal for a board game to Hasbro and you go up there and you give them your NDA, chances are very good that the Hasbro people will say, thank you so much, but we're not going to sign your NDA. You're going to sign our agreement, which is much stricter, but you can at least try. Next, don't let others use your work without a carefully drafted license. And just as I said that you need to get the rights in the license that you're getting to do what you need with the work, your license to somebody else should spell out what they can and can't do with the work. And again, Ted will talk about software licenses. If you're offering your work to the masses, like via a website, then this license should be in your terms of use. And again, users should have to agree to them. And your license should refer to any NDA that's already been signed. Now, this last slide is overlaps with IP because advertising involves your trademarks and your content. And this is pure issue spotting. Be really careful when using influencers. The Federal Trade Commission has issued many rules concerning what influencers have to say when they're promoting your product. If you run afoul of those rules, you will be in big trouble. Same when you are conducting contests. There are 50 states with 50 different sets of laws about contests. Sometimes you even have to post a bond for a contest. You need to know what those are before and also the different platforms have their own terms for contests, but you also may run afoul of law. Making charitable solicitations. If you want to say in your ads, if you buy our product, 15% will go to save the rainforest. Okay, like that also is a matter of state law. You need to be very careful and know what the laws are before you do that. Finally, engaging in comparative advertising. When you say my brand is better than brand X, just better, or my brand of hot pot cooks faster than brand X, you had better be sure that you can substantiate that through appropriate testing. You can't just say it. You will be liable for false advertising. I think I am slightly over, for which I apologize, but that is it. And I will unshare.
Jessica, thanks very much. We have some questions that we'll get to at the end on trademark and copyright issues, but now we'll turn it over to Ted. Ted?
Okay. Can you hear me, Paul?
We can hear you.
Okay. Let me, so I have to get this window up. Ding. Is that share working? Because I'm sorry. Bear with me a second. Share. Present. How's that? Is that working?
Yes.
It is.
Good. Okay. Hi, I'm Ted Sabity, and thank you, Jessica. We're going to be talking a little bit more narrowly about IP in relation to tech startups. Going to the next slide. There we go. All right. So whoops, back a slide. Jessica mentioned copyrights. We're going to talk about that briefly. We'll be talking about copyrights in code, website components, audiovisual stuff on your website. And the key thing here, especially in light of software, is that copyright protects the expression. And in the case of software, that would be the source code and the object code, but it doesn't it doesn't protect the idea. So if I have a new way of, I don't know, accessing or interfacing with a database of some kind, and I have a piece of code that does it, the code can be protected from being copied without a license. But if somebody reads the code and goes, oh, that's how you do it, and they go off and they tell somebody else how the process works. We call that clean rooming, by the way. And that other engineer who had no access to the first piece of code takes that idea and writes their own code. That is not copyright infringement. And in fact, that's something that companies do. They call it clean rooming the code, because in order to infringe a copyright, you have to have access, and the code would have to be substantially similar. So you might have a case if I read the code and then I write my own code that does the same thing. Somebody could arguably say, well, there's access and substantial similarity. But of course, if the only thing that's similar is the functionality, that's the idea. And now that's not protected by copyright. So really, copyright in your code is an effective protection. And you do need to take care of that, but it's not the entire thing. And for that reason, we're going to also talk about patents and trade secrets, because that's also part of how you protect your IP, especially in the technology sphere. So let's talk about trade secrets. What kind of things are trade secrets? Well, source code can be a trade secret if you don't publicize it widely. Certainly, if the source code is kept private and you only distribute the object code compilation, that would be a way of protecting the source code. The data that you may be using on your server, of course, that can be considered a trade secret. All your customer data or the data that's entrusted to you can be considered a trade secret. And a new one that's come up is a neural network, actually, is an example. We've been working a lot lately on AI and neural networks. And it's interesting because neural networks have a lot of trade secrets in them. And I think it's important to recognize that, because as to whether a neural network is patentable subject matter or is something that can be copyrighted is an interesting question that we could spend an entire day discussing. But certainly the inner workings of a neural network, to the extent they're not published, can be a trade secret. Now, what trade secrets do is it prevents improper disclosure or use, basically by contract, by non-disclosure agreement, which we'll talk about in a bit. The third thing we want to talk about in terms of tech startups is the question of patents. So what does a patent provide you? So a patent lets you prevent other people from making, using, or selling something that infringes the claims in the patent. So that can include, now compare this to copyright, the actual process that a piece of software executes. So while the copyright doesn't protect the idea or the underlying idea of the process, the patent may do that. Obviously, patent can protect the device itself. And USPTO has said that AI and neural networks are patentable subject matter, which is interesting to me. I off the top of my head, I know that we'll talk about this a little later. There's a question about patentable subject matter in software, and there's a window that came up. And so the point is that the patents, the trade secrets, and the copyrights work together. And what we do in this shop is we try and come up with a IP strategy where we're using the right components of these different IP regimes in order to further the strategy of the business. And of course, trademarks is part of that, which we aren't talking about in my talk, because Jessica's presented a lot of great detail about that. And that there is, the question of branding also comes in. But right now, we're going to talk about these particular regimes. So now on to the next slide. The potential pitfalls, because I want to talk generally and not get into too much detail, so you know the kind of things you have to look out for and talk to your counsel about. So one of the pitfalls is you need to own the IP you pay to have created. So if you're going to hire somebody to write your code, and that happens a lot now. I mean, I know I have several clients that are contracting outside groups to actually write the code. You have to make sure that the contract is conveying to you or your company all the rights that you need that are embodied in that. And it's not just the copyright assignment. It includes the rights in the patent. It includes that they are maintaining the code they're writing as your trade secret, not theirs. And you have to be very careful about how those are drafted, because when those companies send you their form agreement to do this development for you, a lot of times it's drafted very favorably to them, and those form agreements can very often not give you enough ownership. You need to control your trade secrets and confidential information, and that's critical. You need to you can't just say, I have confidential information and somebody signed an NDA. You have to actually police and make your data protected, take reasonable efforts to protect your trade secrets in order that they be considered confidential. So one of the defenses to breaching an NDA is, well, they never actually kept the information confidential, so how could it be subject to the NDA? So it happens a lot. They get somebody over here to sign an NDA, and for that same information, they email as an attachment to somebody over there. So now that fact comes out in a litigation, and that in a USB stick. The other thing to talk about is you need to make sure you have the rights to use and distribute the IP in your product or service. And this is very important in software, because everybody goes out on the internet and grabs snippets of code and then they integrate it into their software. And now you have a question of what's in there. And I'll tell you where this becomes a pitfall. Very often when you enter into an agreement or you negotiate an agreement, either in an M&A context, you're selling your company, but more importantly, large customer wants to use your software, they're going to make you make a representation and warranty that your software has nothing open source or so-called free software in it. So what happens in those situations, listen carefully, is when I negotiate on behalf of this early stage company licensing the technology, is okay, well, there is free software in it. Well, we will lay out where it is, so you know what's in it. So it'll be, except for what's in the exhibit, there's no free software. So now you have to be sure you know, when you're putting your software together, which free software modules are in there and what license they came with. And you have to keep track of that in the software development process so that down the road, you can identify those, because sometimes some of those pieces are very benign and customers go, that's fine, we know that license, that's fine. But you need to be able to identify it. So the point to think about is IP issues apply to what you create or what's created for you and what you're using or integrating into your web service, software, product. Okay? So in software IP can embody copyright, patent, and trade secrets at the same time. So what we often recommend is in the area of software is you file what they call a TX copyright registration, because in the software world, what's very important is that infringement damages apply starting with the date of registration. So you do want to file, you definitely want to register in many cases. Now, some clients don't do it because the code resides on the server, so it's not a distributed piece of code. This is something we would discuss with the client in terms of the strategy. Maybe it's, well, we only need the client. When I refer to client, now I'm talking about client server. We only need the client software to be registered with the TX because that gets distributed. Everything else is on the server. We don't file on that. So sometimes that's done, but that's something we can discuss. You need to make sure the software is licensed with covenants not to reverse engineer or decompile it. And that goes to the trade secret question of the source code. Because it has been viewed in certain cases that if you have object code licensed without a covenant not to reverse engineer or decompile it, then that means the decompiled source code is not a trade secret. So, and it gets kind of interesting that way. Now, note that in some countries in Europe, you're not allowed to have no reverse engineering clause in some circumstances is unenforceable, but we're not going to get into that complexity today. Now, source code, generally speaking, is considered a trade secret and should be protected that way, but also the data and also the APIs that you might be using. That has to be very, very, very carefully considered. And repeating this potential pitfall, what rights come with that free quote-unquote code that you're using? You found this on GitHub, you're integrating into your product. You better think about what that license is. And this is very important. Make sure your software developers are keeping track. You need to be, because I'm telling you, you don't know how many software developers just grab the code, boom, 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 and they forget where they got the code. So that is something you have to manage very carefully. The people doing your project management have to be on top of this. Protecting trade secrets with non-disclosure agreements. And this is something we just talked about. Trade secret status may be lost if the secrecy is not maintained. So you need to make sure you're securing your computer systems. Who has passwords? When are those, the whole password management thing has to be maintained right at the beginning of the startup. Prohibit and prevent data going for a walk. You have to make sure that people can't just download the code, stick it on their iPhone and say, well, I'm going to do a little bit of code development on my iPhone. Maybe not. So you got to think about that. And let's talk about non-disclosure agreement. And the key thing about non-disclosure agreements here is this. There is no one-size-fits-all non-disclosure agreement, okay? You can't say, I have a non-disclosure agreement, and this is what I'm going to use for everything. And I've seen this too many times. So usually when you're talking to a potential business partner, by partner I mean not legally a partner, I mean a potential transaction, everybody says, well, we'll enter into a mutual non-disclosure agreement. Well, that's fine because it's part of the dance of getting a relationship going, and that's sort of the first date. The mutual NDA is typically very weak and has a time limit, and that's fine for certain kinds of information, typically what the business plan is going to be. Next year's product is going to be a bobble doll. Okay, great. So we're going to make a bobblehead doll that's coming out in, next year. And, but what is the time value of that trade secret? 1 year. So the mutual NDA that says we promise to keep that bobblehead secret quiet for a year, that's good enough for that type of secret. But on the other hand, it may not work as well if the product you're coming out with is, well, in a year, we're going to be coming out with a new piece of code that does some amazing, thing in terms of graphics or what have you. Now all of a sudden it's like, well, wait a minute, 1 year is not good enough for that trade secret because the code itself, it has a trade secret whose value is longer than 1 year. And so that mutual NDA isn't what you want. Now you need to have really your unidirectional, that's your company's NDA that has a stronger covenant with no time limit, preferably. And typically the way this dance works is you're talking to the potential customer, licensee, what have you. They sign a mutual NDA, and you have to meter what you're saying. Unfortunately, your lawyer isn't there in that conversation. So this is where you're going to have to figure this out that, well, maybe I don't want to spill the beans on exactly how that magic software works. They ask you, of course, well, gee, how do you do that? Oh, you want to find that out? Well, let me give you my other NDA that you need to sign before we tell you. That's how it's done. And that is how you get the unidirectional into place. The other important NDA, which is crucial, is the NDA that has to be signed with all your employees and all your contractors, okay? You have to have one because that goes back to how do you maintain the trade secret. So let's talk about patents because I know everybody wants to have some discussion about that. So this gives you the right, if you have a patent over, say, your software process. Now, when I say this, there are going to be purists out there, I'm sure, saying, Savvy doesn't know what he's talking about. You can't get a patent over software. Technically, those words are correct, but we all know that the underlying process that the software is executing may be patentable subject matter. We'll talk about that in a second. So when I'm being really fast here and saying getting a patent over your software. So it gives you the right to exclude making, selling, using, or importing a claimed invention or even the product of a claim process. So I won't get into that detail right now. So it could be the process executed by program code or website code. It can be devices, systems. So, you could say my slide's not 100% accurate, so the purist would be right on that. So, but when I refer to code in this context, I mean the process of what the code is doing. But here's the key thing. It has to be what they refer to as patentable subject matter. So are computer processes patentable subject matter? I mean, mathematics is not patentable subject matter. Well, it depends on the claim and how it's drafted. And there's a tension in the law right now. And in fact, I'm actually appearing before the U.S. Court of Appeals Federal Circuit in a case regarding a patent claim that we filed that the Patent and Trademark Office said is non-patentable subject matter, and I believe they're wrong. So I've appealed that all the way up to the Federal Circuit. There's a tension between patents cannot be granted in abstract ideas that the Supreme Court points out are the building blocks of human ingenuity. And the other problem is that an invention, by definition under the statute, has to have been conceived by the inventor. And, a patent claim by definition is going to provide a monopoly over the conceived invention. And this tension between these two principles has created this flowing gray area in the case law that goes back and forth as to whether this particular patent claim is patentable subject matter or not. And it's so esoteric, the courts can't figure it out. And in any case, what I'm getting at is, don't assume that what you want to patent is or is not patentable subject matter. You want to get competent advice, because a lot of it turns on exactly how you want to structure the patent claim. So to get a patent, you need to file an application at the U.S. Patent and Trademark Office that meets all sorts of complicated requirements. And that thing sits in a queue and it gets examined. There's interaction between me or whoever your patent attorney is and the examiner. And hopefully you get a notice of allowance, you pay the issue fee, and now you got a patent. And much as Jessica mentioned with trademarks, you got to pay maintenance fees every few years to maintain your patent out in the field. So patent pitfalls, because this is where you as a entrepreneur have to kind of know when to call your lawyer up. Time is not on your side, because you can't get a patent over the prior art. If something is out there already before you filed it, somebody disclosed it in a paper, somebody's selling a product or service, you can't file a patent on it. It's over. So time is not on your side. Your own marketing and commercialization may be considered prior art to your patent application. So the filing date, though, when you file that patent application, stops the prior art clock. But the new first to file rule means that somebody else's filing on the same kind of invention ahead of you is prior art. So the kind of rule that has come out of this is people say file early and often, and we do this. We file provisional applications as the software project is developing, and then we file a utility application combining all of them together. And within that year that the provisional application is the first one is pending. But be careful. A provisional application is not a patent. So this goes back to this thing as finding cheap services on the internet that are delivering legal services without being a law firm. You know why they do that? You can't sue them for malpractice because they're a corporation or an LLC. So in any case, that's why it's so cheap. The provisional application is not a patent. It's a filing date for only that which it discloses. So people have come to me where they have filed their own provisional application of one sentence. This is an invention where I invented process X, and they're very happy. I have a provisional application. It's just like, oh my God. So the provisional application expires in a year. It doesn't get examined. Cheap provisionals like you get from LegalZoom. Oops, excuse me. Did I mention somebody? So cheap provisionals that you get from some of these internet services often are insufficient to support an actual filing date for the question of Section 112 enablement and disclosure of the invention. And if you lose that priority date, now all of a sudden, instead of your provisional application being the filing date that's supposed to stop the prior art clock, It's the follow-on utility application that happened later. But if there's any prior art in between, goodbye utility patent application. So don't do this at home. Talk to somebody that knows what they're doing about this stuff, and talk early, because you need to understand, you need to get a filing date before you go too far down the road if you think patent protection is something that's going to be of use. Now, how do you know that? Well, come talk to us. We'll discuss that. So examples of IP in software, you could have a TX and the copyright over the code. You have a visual work copyright, like Jessica talked about, over the appearance of the user interface. And we've gotten all of these for people. You could have a patent over a process executed by the code. You could have a design patent, which I didn't have time to get into, and it's different than a copyright. It looks similar, but it's different. Most importantly, because you don't have to prove access to show infringement of the design. So design patent over the appearance of the user interface, we've gotten those. You can even have trademark rights in the look and feel of the user interface in certain cases. And there's litigation over this. So there'll be purists going, oh, wait a minute, that's not true. What about that Apple case? Well, it depends. But in theory, technically, you could have a look and feel of the user interface introduce a trademark right. And of course, you have like a trade secret in the code. And one of the trade secrets to consider is the neural network weighting coefficients. So then get an IP assignment. So you need to get an IP assignment from all your employees and all your contractors. It can be combined with an employee contractor NDA, all in one thing. And work for hire is tricky. You hear this phrase improperly used all the time. And my recommendation is go ahead and say in the agreement, this is a work for hire, but you have to have that catch-all that to the extent it's not a work for hire, I hereby assign all right, title, and interest, yada, yada, yada. So in any case, you need to include your product designers. Many people have the software writers signing these documents, but they don't get the artists that are designing the appearance of the screens or the user interface designers. Everybody's got to sign this. That's my opinion. So to that extent, to give you examples, and this is not legal advice, but an idea of a mutual NDA for short life trade secrets, unidirectional NDA for a long-term secret, an example employee contractor IP assignment form, and a basic IP startup IP checklist. You can come to our website. You know, we've got one there. It's it's not legal advice. It gives you an example of the kind of what kind of documents you kind of need to have kicking around in order to start getting a handle on what you've got going on here. And so with that, I'll say thank you very much. And I guess we turn to the Q&A program. Let me escape out of this. And how'd we do? 103, not bad. That was pretty quick. Bing. All right. So that was pretty it. That 15 minutes of IP.
Everything you ever want to know about IP, but we're afraid to ask. And,
15 minutes.
All right. Well, listen, Jessica and Ted, thank you both very much. It was a lot of material in a accelerated presentation. So I've got a bunch of questions here, some that came in during the event and some beforehand. We'll get to as many of them as we can. First, I think one for you, Jessica, regarding trademark conflicts. So the person asks, I own a domain name and was contacted by a UK company who told me they owned the trademark for the word. It's a common English word in this person's domain name. And the question, how did they even get that trademark?
That is impossible for me to answer without knowing the facts, although I did mention, first of all, when you say a common word, that doesn't mean it's generic, which you can't get a registration for a generic mark. If it was a merely descriptive mark, and they could show that that mark had acquired distinctiveness, which is what I talked about, like TV Guide, when you hear that very descriptive phrase, you think of the one publication, there was only one TV Guide. Maybe they could show that it had hit that level. That's the most I can say without knowing the facts.
All right. So I'm going to make the suggestion that Jessica, you'll stay after, and if this person wants to join you at the table, they can you can discuss further.
Sure.
A question, I think for you, Ted. I am an inventor owner of patents pertaining to my software, but lack resources to mount a suit. My attorney has advised any cease and desist notice would be ignored by recipients, and the dollar potential not enough for his firm to pursue, I guess. How can I enforce my IP rights?
Well, that's a tough question. I mean, if the IP itself is of little value, it gets very hard to enforce your IP rights. And, you know, you can show up in court pro se. Generally, that's going to be very difficult. But, you know, the reality is the people that work on these kinds of litigations, they have to make a living. So, as you know, you're either going to have to pay them per hour or some kind of fee, or ask them to do it on a percentage basis. And if they don't see any value there, it's going to be hard to get them to enforce it. The only thing you may consider is if you send a cease and desist letter, there are two things that happen. One is it puts this company on notice that they may be infringing your patents. And this raises the stakes for them, because if you do ultimately successfully litigate and find that and the court rules that they are infringing, they could be subject to what's called willful infringement, which multiplies by 3 the damages, plus gives you the opportunity to get your attorney's fees paid back. Now, getting attorney's fees back, I can tell you from experience, is very tough. But nonetheless, it opens that door and raises the stakes for this alleged infringer. On the other hand, if you send a cease and desist letter and then you don't do anything for 5 years, they can bring a defense of what they call latches, which is they knew we were infringing, they warned us about it, and they never bothered us again, so we assumed they didn't care anymore. And that is a defense and can limit your damages claim as well. And there's a third thing, is that there is effectively a statute of limitations on infringement from your date of knowledge to when you bring the case. So if 6 years goes by, it's over. So unfortunately, that's just the reality of litigation, that if you have a patent that's being infringed, but the amount of damages are going to be very limited, the only thing that becomes potentially useful is the notion of getting what they call a preliminary injunction. So that's where you get the court to issue an injunction pending the outcome of the case. And that's usually when people are able to force the infringer into a license, because they don't want to shut down their business while the lawsuit's pending. But as I said, even getting to that point, you're going to have an attorney conduct the litigation. So
can I add a comment?
Yeah.
Yeah, please.
The other possible consequence, let's say you send a cease and desist letter and you hope that they'll roll over, but they don't, and you really can't afford to pursue it. Well, once you let them know that you're thinking of suing them, that you think that they're infringing your patent or copyright or trademark, they may take it upon themselves and go to court for something called a declaratory judgment.
Yeah.
Ask the court to say, I am not infringing or whatever it is. And the other thing that happens when they do that can happen. Let's say you're in Texas and they're in Rhode Island. So you've sent your letter. Now they're going to sue. Not only are they going to sue for a declaratory judgment, but they're going to do it in their own home state. They're going to forum shop. So this is all a way of saying it really is very tricky. You really do need to speak to someone.
Yeah.
The answer may be, we cannot help you, but maybe we can help you from shooting yourself in the foot.
Yeah. So sending out a cease and desist letter, and Jessica's right. I forgot about that. I knew there was a laundry list of things we have to sending out a cease and desist letter is a big, big deal. And I've had clients complain when they go, wait a minute, you billed me how many hours before you sent the letter? I said, I don't send a letter out till I've confirmed the facts as reasonably as I can, and that we've gone over all the things that could possibly happen and what our position is. and have explained them to you before we push the button and hit send on that email. And that's the key thing. So unfortunately, getting advice costs money, and that's just the way it is. I mean, I don't really have an answer for that.
All right, thank you both for that. Another question here. A retailer says, if I have a catalog with 15 items on each page, and it's 150 pages long, would I want to file a copyright can I file a copyright for each page as long as it's part of a theme?
Sure,
So,
if you hire me and I charge you by the page. No, sorry. Yeah, sorry.
but the point is,
Yes.
does there need to be a separate filing for each item on the page?
No, you can file a for what's called a collective work, which is a work that consists of items that could stand alone on themselves, like a photograph of a product. There are ways to file for copyright where you can put all the things in one application. There are specific rules about the kinds of works that you can do that with, but it is possible. And if you go, not to shoot myself out of fees here, but if you go on the Copyright Office website at copyright.gov, G-O-V, go to the circular section. They have a lot of really well-written brochures that explain some of the basic principles and things that would also cover that. You have to look in their whole list of topics. I'm not saying you shouldn't consult a lawyer, because often you should, but that would give you a good starting point.
All right, thank you for that, Jessica. Another question, perhaps one for Ted. When collaborating with academic institutions for research and development, such as in the medtech space, how can a startup protect its interests?
I'm sorry.
What are the possible ways to negotiate intellectual property rights sharing contracts?
That is a really good question, and we've done a bunch of those. And you're raising what's referred to as the Bayh-Dole Act. The Bayh-Dole Act provides that if the federal government funds some research and an invention comes out of it, the federal government has a non-exclusive right to that invention. In addition, we have found with large hospital organizations that are getting involved with startups doing medical informatics of various kinds, and we have several clients in that field, and we've done these deals. The issue also turns on the question of the clinical data that may be used in the in this data processing research, and that also overlaps with HIPAA as well, and the whether or not this organization that's doing this data processing research is going to be a proper what they call a business associate. So there's a number of complex issues there, and you need to be very careful. It is possible to negotiate these issues because there are sort of different kinds of things. There's the question of if the large institution is considered a co-inventor of the invention, can you capture those rights from them at the get-go and say, look, if we do this together, we need to have some kind of rights to that? The answer is yes. It's a matter of negotiating leverage, to be honest. I mean, we did a deal with MIT involving some AI development in the medical field, and I was surprised that MIT was very, very easy on the patent question, and because the leverage of my client was pretty high in terms of what they had in their back pocket, what they were bringing into the party, and so the researcher at MIT was like told their office, no, we don't. They can have rights. Or if we're not going to end up inventing, but if we end up inventing, let's let them have the exclusive because they're going to use that to fundraise to commercialize what's going on. So it really depends on your leverage, but there are a number of overlapping complex issues in negotiating a medical informatics data processing development deal with institutions that may be federally funded, or even if the research is not federally funded, they just have their own IP policies, and it also interacts with HIPAA. So that is do not do this at home. This is where you definitely have to have somebody experienced that have done these deals I mean, I don't mean to toot my horn, but we have. And in terms of getting these multiple things right, in order that the company that has the basic idea that's been starting this project is not going to find that its IP has been dissipated as a result of how it entered into this kind of an agreement. And if it's getting federal money to fund it, that they've got that set up. And there are a number of strategies and tactics that we've used in this context. But without knowing the facts, it's hard for me to say more than that.
Can I say one other thing? I don't do what Ted does, but it's so important that you understand that in negotiating just about anything in the IP arena, as with everything else, it is all about leverage. And that's it. I mean, you want to negotiate good license terms. If you're negotiating a one-to-one license, it's if you've got the leverage. And I just wanted to make that clear.
But there's one exception, and that is the federal.
We have to wrap shortly. But please.
I'm sorry. I just want to point out the federal regulations over the FAR. The acquisition regulations has specific requirements that you can't negotiate. It's like
military.
Money. That's the deal. So anyway, sorry.
Well, listen, Ted, Jessica, thank you both very much. A whole lot of very valuable material in a short amount of time. I think you're both going to be able to stay afterwards. So if people didn't get their questions answered or not fully answered, join Ted and Jessica at the tables in the virtual lounge. I should also mention that, hey, could you put up the disclaimer slide for a second, Andy? I should also mention that I should remind everyone, we have not been providing legal advice. This is an informational event. You are if you need legal advice, you should be consulting with an attorney licensed to practice in your jurisdiction, as detailed on this slide. Also, I should mention that this is in a series of events on legal topics for startup companies. We've done a lot of events on financing, whether it's venture capital or angel. We've done events on how to start a company, how to sell a company, how to negotiate your exit. And all of these, we have videos on all of these. They're available on the YouTube channel for Tech Alliance. They're also available on the resources page of my firm's website. And we urge you to go and take a look at those, because there's a lot of great content in those videos there, available for free. With that, I think Andy, I'll turn it over to you. Jessica and Ted, again, thank you for your presentation.
Awesome. Thank you so much to everyone who participated today. Thank you for attending the event. Please stick around if you have a few minutes to connect with both Jessica, Paul, Ted, and thank you again. We hope you enjoyed. Have a fantastic afternoon.
Take care.